Hello, everyone. Hello, friends. Good morning. My name is Ifeoma Odalami. I'm an immigration attorney in New Jersey, but my law firm serves clients in all 50 states of the United States. And today I have a great topic for you guys. So I'm just going to wait a couple of minutes so that I can get a couple more people. And I hope you guys are all doing great, and I'm so excited for this topic that I want to share with you because I've had people come to my office all frantic because they don't realize that they have a way out. So that's why I do these videos, because I want you guys to understand what the rules are, to understand how to get your green card, and so that you can leave and live without fear. You can leave a bad relationship and live without fear. So, guys, I'm ready to dive into this. Are you ready? So, sign in and let me know you're here. I'm going to go through my presentation and then I'll take questions. I don't have a lot of time today, but I'll try to take a couple of questions. So I'm going to talk about getting a permanent green card. So, if you're married to a U.S. citizen, right, and the at the time you get your green card, it's less than 2 years. What you get is a temporary green card, aka conditional green card, aka 2-year green card. That green card only lasts for 2 years, right? So how do you know? If you're not sure what you have, look at your green card. It will tell you when you were given the green card and when it expires. So if it's 2 years, you know that you have to remove the conditions. And remember this: if you get a conditional green card and your children get a green card through you, their green card depends on your ability to remove the conditions on your green card. So to remove the conditions on your green card, let's get started with how that works. So you're married to your US citizen or green card holder spouse, and it's 90 days before the expiration of your 2-year green card, and you need to remove the conditions, right? So removing the conditions requires you to file jointly with your spouse. Your spouse is supposed to file jointly with you to remove the conditions on the green card. And the reason for this is because your marriage is new, because you got a 2-year green card, because your marriage was not up to 2 years at the time you were given the information. So USCIS wants to take another look at this relationship to make sure it's a bona fide marriage, which also known as a good faith marriage. There are many things that you can be forgiven for in immigration, but you cannot be forgiven for a sham marriage. I say this all the time. A sham marriage is a marriage that's entered into for immigration benefits only. So USCIS does not forgive that. There's no waiver for it. It's a permanent bar. So USCIS is always looking for an opportunity to take another look at this marriage. If you have to remove the conditions, they want to look at it again to see and make sure that it's a real marriage. Now, what's the definition of a bona fide marriage? It's a marriage that you entered into with the intentions of living together, building a life together with this person at the time you married them. That's what it means. And so, how do you show that? The burden of proof is on you, because USCIS does not know what's going on in your home. So the burden of proof is on you to show that it's a bona fide marriage. And how do you show that? We're going to talk about it. I have lots of videos about this, so I'm going to talk about that real briefly, and go through my videos. And I've had video recordings that deal only with what to present when to prove a bona fide marriage. So when you first get married, you know that sometimes you don't have all the information. You don't have proof of financial commingling. You may not have proof of joint taxes because maybe you haven't gotten your social security number. Maybe you haven't gotten a job, a whole bunch of things, right? And so you may not have a lot to submit. You may just be able to submit things that show that you're married, maybe your wedding pictures, maybe some affidavits from family and friends, that kind of stuff. So when it's time to remove your conditions, you've been together for a couple years now, so USCIS wants to see more. So at this point, you should have your social security number. You probably have a job, and you and your spouse should have filed jointly your taxes jointly. If you have children, you want to submit birth certificate. So you want to show what has happened since you were given the green card, right? So don't submit the same old stuff you submitted. You want to submit updated stuff that show that as of today, when we're filing the joint removal, we're still, it's still we're still a couple, and we're still in a legitimate relationship, and this is the proof, right? You can show driver's licenses showing that both of you live in the same place. You have the same residence. You can show utility bills show either in both your names, or utility bills in one person's name and another one in another person's name, but showing that both of you are residing in the same place. You can show if you have health insurance, which is really good. That's a really strong proof of bona fides. Health insurance, evidence that you're raising your children together. For instance, even if it's your stepchildren, are you an emergency contact in their school? If you've gone on vacation, and you can show the tickets, where you flew to, even if you drove, maybe you went to landmarks, maybe well-known restaurants. Say you were traveling through DC, and you went to the White House, took a picture. They just want to have a slice of your life. So you really want to, because I believe this, right? That the package you submit, I think, determines to a large extent the mindset of the officer who's interviewing you. Because if you submit something that's very skeletal, they come in with a notion that it's not a real relationship, and sometimes that interview can get a little hostile. So, well, hostile in the sense that they ask you questions, and you don't feel comfortable, and they think you're faking it, and you make more mistakes because you don't feel comfortable. So, you really want to make sure that when you put in the submission, and the form you use is Form I-751, you want to make sure that you're putting as much evidence of a bona fide marriage, okay? So now, the question I get all the time, which brings clients coming to my office all worried, is what happens if this relationship doesn't work out? What happens if your happily ever after does not go the way you wanted it to go? Well, this is good news. USCIS does not want anybody to be in an unhappy relationship or unhappy marriage. They don't want you to stay in an unsafe or unhappy marriage because you're trying to get your green card. So they're what we call waivers, right? They're exceptions to the joint filing requirements. There are four of them. Number one is divorce. You can divorce your spouse, right, at any time after marriage, and you can still get your permanent green card. So if you're married for 6 months and it's just not working out, you don't even have to wait for the 2 years. You can get a divorce. Once divorce is through, you can file to remove the conditions with your divorce decree. However, you must show that it's a bona fide marriage. You must show that even though you're divorcing your spouse, that the marriage was real, it was legitimate, and you have to provide all the information to show this, because if you don't, you could be denied. So the second is if you are in an abusive relationship and you can't take it anymore, you shouldn't even take it at all. So if the relationship is not working out because your spouse is abusive, right, you can file to remove the conditions on your own. You don't need your spouse to file with you. Same with a divorce. You don't need your spouse to file with you. Those are exceptions. So let me talk about the extreme cruelty or battery requirement. So abuse can be physical, which means your spouse is, hitting you or putting you in unsafe locations. It can be psychological, it can be emotional, it can be verbal, it can be financial abuse, it can be sexual abuse. So just because your spouse is, just because the type of abuse you suffer is not physical, does not mean that you cannot get your waiver, right? So, but you have to show it, because it's always your burden to show this. So I've talked about this in at great length, the type of abuse that USCIS recognizes, to be abuse. The types of behavior USCIS recognizes to be abuse. I mean, they make a they designate what they call marital tensions, which they think is not abuse, which they say is not abuse, and then there's abuse. So we try to show that this is not marital tension, this is abuse, so because sometimes the funny thing is, sometimes everything's working out and your spouse, your US citizen spouse or American spouse is kind to you. Sometimes once you get that green card, right, it's as if they feel that you owe them something and you should behave a certain way and behave, you should be more grateful. Maybe you're not acting with enough gratitude and they turn on you. Or maybe now you have your temporary green card, you've now bettered yourself, you now have a job, maybe you're making more money than them, or maybe you're going back to school to become, to get that dream job, and they feel that you've left them behind, or you're going to achieve your dreams and you're going to leave them, and so they turn cruel. But whatever the reason, there's no reason for you to be in an abusive relationship. There's none. Okay? If you want to leave, you should leave. If you want to get a divorce, go ahead and get a divorce. If you don't, but you can prove, or the divorce petition is not ready, has not been finalized, you can show the abuse. Now, if you're in the process of filing a divorce and the divorce hasn't come through yet, and it was a great marriage, but just you guys just it didn't work out, you can also, either wait for the divorce to come through, or if you're at the stage where you need to file your the waiver, you can file it, and what you're going to do, what is going to happen is that USCIS will send you a request for evidence requesting for that divorce decree. So you want to look at the timeline when you do this stuff. And worst case scenario, if your green card expires, it doesn't mean you cannot file to remove the conditions. It just means that if it expires, you are at risk of being put in deportation proceedings. But even if you're put in deportation proceedings, something can still be done. You can still remove the waivers on the conditions on your green card. I've had green cards that were expired from 2013, where the clients had the green card expired in 2013, but they didn't know that they could remove the conditions even if they were no longer with their spouse, or even if it was past the date, until they came to us, and we would remove it for them without an issue, just making sure that we have all the documentary burdens that we're supposed to submit. Now, the third is death. If, unfortunately, the U.S. citizen or green card holder passes away, you can still get your green card. Again, you still have to prove that it was a good relationship, was a valid marriage, and it was not based on immigration purposes only, okay? That it was a bona fide relationship, all right? Then the fourth is extreme hardship. This is really, really, really difficult to prove. You're basically saying that deporting you would cause you extreme hardship. This is the only section that doesn't require you to prove a bona fide marriage, but it's really, really difficult. And basically, a lot of times the people that prevail in this area, people that can show that maybe there's some political problems in their country that's making it unsafe for them to go back there, such as maybe if the person was from Afghan, or maybe Haiti at the time, all this, the political issues were up and going on. So you could, that could be one. But most cases based on marriage require you to prove that it's a real legitimate marriage. Okay. So let me say hello to everyone who stopped by. Hi, Fama Kinwa. How are you? Good morning. Where are you calling from? And Away Sunday says, how can someone get your direct line? Hi, Sunday. You can call my office, 973-993-1900. That's our direct line. It's right here on the banner. Okay, we're expecting your call. Hi, Nkechi. How are you? Hi, Gladys. Hi, Ephraim. Ephraim says, good morning, Odolami Law. I have, let me here, see if I can I put, yeah, okay. Good morning, Odolami Law. I have VAWA. I went to fingerprint 2 months ago. What is next? I don't have permission to work. Okay, Ephraim, that's a great question. So let me just give a little background for people who don't know what VAWA is. VAWA is Violence Against Women's Act. It's the Violence Against Women's Act. It's an acronym. However, it's men can file for it as well, like Ephraim has. Women can file for it, and even children. So let me answer your question, Efren, and then I'll talk a little bit more about VAWA. So you went to do your fingerprint. So typically, what you're waiting for next is a prima facie determination. A prima facie determination is something that says you have made a preliminary showing that you've suffered abuse in your marriage, but we haven't made a determination yet because it takes a long time. It takes about 24 months for a VAWA case to complete the process. But in the meantime, we're going to give you this prima facie determination, and depending on the state you're in, you can use it to get some public benefits. And you can use it to get a driver's license in those states, in some states that do not give undocumented people a driver's license. So now the benefits you get is really state dependent. So if you get a prima facie determination, you want to check in with your state. Now, the permission to work. If you filed an I-485, which is an adjustment of status, at the same time as you filed your VAWA petition, then you should, and depending on the code you put on the work authorization, you should be able to get a work permit within 6 to 8 months. The work permits are really, there's really a huge backlog on this work permit. So 6 to 8 months is really right about average. Now, if you put a different code on the work permit, you could wait until your VAWA is approved. So it depends on the code you put. That would determine how soon you get your work permit. And typically when you get your work permit, if you also filed for advanced parole, you should also get advanced parole, which allows you to travel out of the country while your case is pending. I hope that answered your question, Ephraim. So another thing, this brings me to something, some people confuse VAWA with the I-751 waiver of extreme cruelty and abuse. And yes, they're similar, right? But they're two different petitions. With the I-751, you have a green card already, so you're trying to remove the conditions to get a 10-year permanent green card. With the VAWA petition, you don't have a green card. So your spouse is either not filing for the green card for you, or maybe you were in the process of filing for the green card and the abuse was occurring and you didn't want to go through it anymore, and you decide to go through the VAWA route, because the VAWA is a self-petition. Or maybe your spouse filed for you and you were denied for whatever reason, and there's abuse in the relationship, and you can also prove that it's a legitimate marriage, because VAWA needs you to prove that it's a legitimate marriage first. Like I told you, most marriage petitions require that you prove that it's a legitimate marriage. So that's the difference. But the abuse, the extreme cruelty portion of the I-751 waiver and VAWA, it's the same. It's the same abuse that they're looking at. Another difference is with the I-751, you may be called for an interview, right? And they will grill you on what happened in that marriage, the abuse you suffered. In VAWA, they don't do that, right? VAWA, you do have an interview when the VAWA case has been approved, you still have the I-485 interview. But at that I-485 interview, they're not asking you questions about the abuse you suffered. They're really just making sure that you have no inadmissibility issues. So that's, I hope that answered your question. So let me look to Edwin. Hi, Edwin, how are you? And Kiki says here she has a question. Kiki, what's your question? Because I have a couple more minutes more. So shoot, let's hear your question. All right. Kiki is male. Kiki, I don't see any question here. All right. So if you guys don't have any other questions, I'm going to sign off. But I'm going to ask you, if you got value from this video, please share it. Subscribe to my social media so that when I put a new video out, you guys are notified and you can come in and ask me the questions. This is your time to ask questions. You can come in and ask me the questions and I'll respond to the best of my ability. And so I'm on Facebook, LinkedIn, Instagram, TikTok, and on YouTube. So follow me on all of those so that you can be updated whenever I come on. So take care, everyone. Again, my name is Ifeoma Odolami. I am an immigration attorney at the Odolami Law Firm, where we fight for fellow immigrants and their American dream. Take care, everyone.